reviewing California legislation during the 2022 session, and particularly the bills that reached California Governor Gavin Newsom's desk, I noticed a number of bills that contain a severability clause. What's the purpose of this clause? Basically, a severability clause is a statement by the legislature that if a part of a law is enacted and is subsequently held to be invalid or unconstitutional, then the severability clause ensures that the unconstitutional that the unconstitutional provisions don't invalidate the rest of the law. As a result, the general rule developed and applied by the courts in this state is that if a portion of a statute is invalid or unconstitutional, then the remaining portions of the statute are held valid and enforceable as if they were standing on their own. On the other hand, if the remaining portions are completely dependent on the invalid portions, then even the remaining portions also are deemed invalid by a court. As an additional general rule, a bill drafter should only use a severability clause when there's a possibility that a statute could be partially invalidated, and it may not be clear that the intention of the legislature is for the bill to be either severed or the entire bill to fail if any portion of that bill is held invalid. Now, others believe a severability clause is unnecessary for drafting purposes and even for legal purposes because the courts in this state and elsewhere in the nation actually have repeatedly ruled that regardless of the presence or lack of presence of a severability clause in a statute, the courts generally sever the invalid portions from an otherwise valid law whenever they can. So the following example I'll read to you is sort of the standard language found in most California bills. The provisions of this bill are severable. If any provision of this bill or its application is held invalid, that invalidity shall not affect other provisions or applications that can be given effect without the invalid provision. Now, when I was reviewing those bills during the 2022 session, the measures that reached the governor's desk, I found the following example I'll read of a unique severability clause that was contained, and it was actually titled Article 5 of the bill, Severability. And it said, the provisions of subdivision C of section 65912.131 concerning healthcare expenditure are distinct and severable from the remaining provisions of this chapter. However, Article 4 is a material and integral part of this chapter and is not severable. If any provision of Article 4 or its application, exclusive of those included in subdivision C, is held invalid, this entire chapter shall be null and void. Now, why do I think that this language is particularly unique? Well, first, the bill language explicitly provides that certain provisions of this bill are distinct and severable, not often used. Second, this language specifies that other provisions are in fact a material and integral part of the act and are therefore not severable. That also does not occur very often. And third, this language provides that if any provision of a specified area of law is held invalid, then the entire chapter is null and void. Also a little bit more distinct a feature than we generally see.